All right, everyone. Thank you so much for joining us today for our presentation on the E-2 visa. This is the visa option that I would say we most commonly help our clients navigate, and there's good reason for that. If you are a national of an E-2 treaty country, it really is one of the best options available for those who want to come to the U.S. to start or grow a business here. So before we get started, a few housekeeping items. My name is Dustin Saldarriaga. I am a senior associate with Scott Legal PC here in New York City. Although our firm does focus on business immigration law, we do handle the full range of immigration options in the US, whether that be family-based immigration, temporary options like student visas or visitor visas, and really anything in between. So we do hope that you'll reach out to us if you have any questions at all related to US immigration. After this presentation, you'll receive an email from us with a few things. First of all, you'll get a copy of the PowerPoint that you see on your screen, so no need to take lots of notes, fortunately. We'll also send you a comprehensive guide on the E-2 visa, and we'll send you a link where you can visit our YouTube channel. This presentation is being recorded, and we do post our full recorded webinars to our YouTube channel, as well as shorter videos. And these do run the full range of US immigration. So we do hope you'll take a few minutes and check out that resource. We are very proud to put out some high quality information to you all for free. We will also, in that email will be a link where you can schedule a consultation with us. During this presentation, we don't get into the details of people's specific circumstances. If you do want to talk about your questions, your options, what might be best for you, do schedule a consultation with our firm. If you have a question during the presentation, send it in through either the chat function on Zoom or the Q&A function. I have both open on my screen, and I am actively monitoring both. There's a good chance we'll save questions for the end, but don't hesitate to send them in. We are keeping track of them. We're very fortunate today to have my colleague, Kelly LeGrand Weiner, who is the managing partner of our firm. Kelly has extensive experience preparing E-2 visa applications, as well as many other visa options. So it really is wonderful to have her on today as a resource. And one last thing before we get started is, not only is the E-2 visa the most common visa we help our clients navigate, it's also a visa that is close to our firm's heart because our firm was started on an E-2 visa. The founder of our firm, Ian Scott, a national of Canada, has personally navigated a TN visa, an H-1B, an F-1 visa, and as I mentioned, the E-2 visa. And this really does inform the way that we work with our clients. We are very proud that because we've seen how the system works and understand what it's like to be on that side of the process, that really does inform the way that we work with our clients. And we're very proud of that. So without further ado, let's go ahead and dive in and talk about the E-2 visa requirements. So the E-2 visa, to start, is a treaty visa. What that means is you do need to have a passport from an E-2 treaty country. Now, there are dozens of E-2 treaty countries, and these are on pretty much all continents except for Antarctica. But they include Canada, Mexico, Germany, the United Kingdom, France, Colombia, many, South Korea, Japan, Australia. Really, you look across the map, and there are over 80 countries. So there is a good chance that your country of nationality does fall into that group. However, that being said, there are some countries not on the list, which include, for example, China, India, Brazil, South Africa. Nationals of those countries would not qualify for an E-2 visa based on their passport. However, they could get citizenship in an E-2 treaty country, for example, based on investment. And that is something we're happy to talk through with people if it's relevant to them. Now, as I mentioned, you only need a passport from an E-2 treaty country. You do not need to have been born in that country. So for example, if you were born in China and you became a citizen of Canada, you would be eligible for the E-2 visa, assuming that you have a Canadian passport. Second requirement, you must own at least 50% of the E2 company. Now, let's take a step back. An E2 company is just a company that is started within the United States. So it could be an LLC, limited liability company. It could be a corporation. It could be a partnership. Really, the form of the business is not particularly relevant. Most of our clients do have LLCs or corporations. So the company that's formed in the US does need to be 50% owned by the E2 visa applicant, the investor applicant. So that does mean you can have two E2 investors associated with a single business, but the only way that can happen is if they each own exactly 50%. The other thing I'll say about that is if the E2 investor owns at least 50%, it doesn't really matter who owns the remaining amount. So, for example, the E2 investor could own 50% of the US company, and the other 50% can be owned by a US citizen, a US permanent resident, nationals of another country, many nationals of other countries. The requirement for the visa is that the applicant, the E2 investor applicant, own at least 50% of the business. And that does need to be maintained. So the moment that the ownership drops below 50%, that E2 investor becomes ineligible for E2 status. So that is critical if you're thinking about selling equity in your US company. Third requirement, you do need to make a substantial investment into the E2 company. So we will talk on a later slide about what a substantial investment is. But for now, the important things to keep in mind are that the funds that you invest into the business do need to be at risk. This means they actually need to have been spent on the US business. It's not enough to simply transfer funds into an E2 company bank account in the US and have them sitting there and apply based on that. You do need to actually spend the funds on the business. The source of funds is also critical, and especially if you're within the US and applying through USCIS, for example, a change of status to E2 status. The source of funds is going to be especially important. And what the source of funds means, you have to prove to the US government that the funds were lawfully and legitimately acquired. So, if you got them as a gift, you need to show exactly where you got the funds from and how the person who gifted them got the funds. If you got them from selling an apartment, you need to prove you own the apartment, that you sold the apartment, and that the funds were transferred into your account. If it's a loan, you need documentation of the terms of that loan and to show how the funds flowed from the bank or whoever made the loan to your account and then to the business account. So it really is source dependent what documents you'll need. But one of the things that we, on essentially all of the cases we prepare, we will sit down, talk with the client about where they're getting the money from and exactly what documents they need to prove that the funds are from that source. Next slide is about how much is enough, what is substantial. And I'll wrap up this slide by just quickly mentioning some typical E2 expenses. The way I like to think of E2 expenses, in other words, what can you and should you spend the investment on, is to ask to make this business operational, meaning it is ready tomorrow to start serving customers or clients. In order for it to reach that point, what does it need? It needs an office space. It needs furniture. It needs computers. It needs printers. It needs utilities. It may need an employee. It might need insurance. All of those things that are necessary for the business to be operational are, by and large, good E2 expenses. There are a few exceptions to that we'll talk about later, including training and classes. But by and large, if an expenditure is needed for the business to be operational, it's going to be a good E2 expenditure. And you see some examples on your screen: a website, office supplies, marketing, etc. So the next requirement is that the business cannot be marginal. So this is a strange term. We don't use it a lot, but what it means for a business to be marginal in terms of the E2 visa context is that it needs to prove to the government that it will hire US workers. So for E2 cases, usually what is sufficient is for the US company to employ at least 3 full-time equivalent US workers within a 5-year period of starting operations. So if the employees are part-time, you would need 6 part-time employees. So these are full-time equivalent, at least 3 full-time equivalent US workers within 5 years. Independent contractors may be sufficient if they are common in the industry and you have a significant number of them. I'd say, 8, 9, 10 ideally. And if they're long-term, that makes it even better. The way to think about this, it is a spectrum. So independent contractors count, but they're weaker than full-time equivalent US employees, full-time US employees. In the middle are part-time US employees, which are great, not as great as full-time US employees, and then independent contractors a little bit weaker. But again, they do count. So particularly depending on the industry and if they're common to the industry. Next requirement, the business must be real and operating. So I already touched on this before when I was talking about the investment and what expenditures are helpful. Basically, what is important is that the moment that you are sitting in your interview at the consulate, it is important that you be able to confidently tell the officer that if the visa is granted, you are ready to get on a flight, come to the US, and the business is basically ready to be operating. That the only thing that's needed is the visa. So the business does not need to be operating before you submit the application. It does not need to be operating before your interview. But the moment you get that visa, you need to be ready to come to the US and the business needs to be ready to operate. So how do you show that? You'd include in your application things like a signed commercial lease, you have office space, proof that you've created the LLC or the corporation, proof that funds have been transferred to it and spent on all the things that are needed for the business to be operational, proof that the business has started marketing, such as through a website. And if you have contracts with clients, that's wonderful. If you don't, letters of intent from people who would like to be clients once the business starts are wonderful to include in an application. Next, you must be coming to the US solely to develop and direct the E-2 enterprise. So the E-2 investor visa is for someone who's coming to the US to grow the business, basically as an entrepreneur or as a manager. They should not be coming to the US to directly provide services to customers. So that's a subtle distinction, but it is an important one, especially if you're applying through USCIS within the US. If you're applying at a consulate, this is less important. But to give you an example, if you're inside the US, you are, let's say you're a student, you've just finished a degree in accounting, and you want to start an accounting firm. You apply through USCIS to change your status from student status to E2 investor status. What is really important is that your role at the accounting firm is to be a CEO of that firm. You're responsible for advertising. You're responsible for making sure that the financials are working, making sure that hiring is going smoothly, supervising your workers. What would be a risky case is if for the first, say, 2 years, you are going to be the only employee and you're going to be the accountant at the firm. So what that does is that means you're going to be competing with other accountants who are looking for jobs within the US. USCIS doesn't like that. So it is important, especially again, if you're applying through USCIS, that you are actually managing and growing the company rather than providing direct services to customers. Also related to this requirement is you do need to, again, own at least 50% of the business, which means you have control over the business, decision-making authority. The next requirement, you need to have the intent to return to your home country after your E-2 status or your E-2 visa expires. The E-2 visa is not a green card. It does not automatically lead to a green card. It is a temporary visa that is for the purpose of you temporarily coming to the US, growing the business, and then once you've achieved that, leaving the US. That being said, it is perfectly fine to renew your E-2 visa as long as you and the business remain eligible. Again, The distinction is that your intention is not to permanently remain in the US. So if you're renewing it for another 5 years to continue growing the business, that is generally not a problem at all, assuming that there are no other indicators that you actually intend to remain in the US permanently, such as a pending green card application. If you have questions about that, we can talk more about that in the question and answer portion. The final point on the screen is just a note that there are really three main options when you're really pursuing a business in the US. The first is to have a startup. So you can create your own LLC, say, invest in it and start the business from the ground up, have a business plan, and you're applying at the consulate based on your financial and hiring projections. That's one option. A second option is to buy an existing business in the US. So you buy at least 50%. The business has been operational. That is an option as well. So for that, we would recommend pay the fair market value of the business. Ideally, it's a business that already has 3 full-time equivalent US workers, and that can be perfectly fine. The third option is to start a franchise. So it's kind of between the two options I mentioned before. It's not buying an existing business because you are starting a new location, but it's also not a startup because you have the track record of the franchise supporting you. So startup, purchasing an existing business, and starting a franchise really are the three main pathways we see for the E-2 visa. How long is the E-2 visa valid for? So when you go to the consulate, you apply, you have your interview. Assuming your interview goes well, you will have a visa put in your passport. The length of time that visa is valid spans from 3 months to 5 years, and that mostly depends on your country of nationality, the country of the passport that you're applying on. Because this is a treaty visa, it's an agreement between the US and your country of nationality. And there are negotiations that go on in that process and something called reciprocity. So if your country of nationality limits the length of time, then the US will limit the length of time of the visa and vice versa. A lot goes into this. So the relevant point is you can Google US Department of State reciprocity, and you can actually see country by country what the validity period is. Countries like Canada, the United Kingdom, many others have the maximum 5 years of validity. Other countries do have shorter periods, as low as 3 months. A few important things to keep in mind. Regardless of how long your visa is valid for, as long as you enter the US while your visa is valid, which is necessary, the visa is only essentially a document that lets you enter the US. Once you're inside the US, the visa is largely irrelevant. But once you do enter the US, you're typically given 2 years of E-2 status. So even if your visa is valid for 3 months, if you enter the US, you're usually given 2 years of E-2 status. Now, once you leave the US, you do need a valid visa to re-enter, and so that's where that 3-month validity period is really a pain. The other thing I'll say about this is that even though a consular officer, a consulate, may be able to issue a visa for 5 years, they may limit the period of time. So let's say you have a startup, the consular officer thinks it's a risky startup. They may say, even though I can issue the visa for 5 years, I'm going to issue it for 3 years. I want you to come back after 3 years. I want to see how the business is doing, and then I'll give you a visa for 5 years at that point if you apply to renew it. Great. So those last 2 points are ones that I touched on. So this is probably the most common question we get. How much investment is enough? I said before, the requirement in the law is that the investment needs to be substantial. So that's not particularly helpful in terms of giving you a firm sense of how much to invest. Something like an EB-5 green card, for example, has a very strict dollar amount, $800,000 or $1,050,000. And that is the requirement. The E-2 visa is not like that. That's both good and bad. It's bad in that, like I said, there is uncertainty around it. So you might invest $150,000, $300,000 into a business, And the government can still come back and say, we don't think your investment is substantial. That does happen. Fortunately, we have enough experience to typically anticipate if that's going to be a problem and to advise you before you apply. But the point is that because of how the law is written, that is a possibility. The benefit, though, is that you can be approved for an E-2 visa with a relatively low investment amount. Um, we have in the past assisted clients who have invested $50,000 and even under $50,000 into the E2 company. Now, that being said, first, that past performance is not a guarantee of what will happen in the future. But the second thing is that if you are investing a low investment amount, and just to give you a baseline, anything under $100,000 we would consider to be a low investment amount. You do need to strengthen the application in other ways. And since this presentation, this webinar is focused on low investment and risky cases, we will be touching on some of those strategies. One of the best strategies, if you have a low investment amount, is to already have US employees working for the company before you apply. I like to say that the employment of US workers can make or break an application. And what I mean by that is if you are already employing US workers, that can convince the government that a low investment amount is less important. So they may be willing to approve a case if you, even if you have a low investment amount, if you're already employing workers. On the other hand, if you have invested millions of dollars into a business, but the consulate is not convinced that you're going to employ US workers, your application will be denied because you have to employ US workers. So US workers, employing US workers really can be a key part of an application, especially if you have a low investment amount. So as I mentioned before, the funds invested in the business, which again, we recommend be at least $100,000. Those funds do need to be spent on things that the business needs to operate. It is generally okay if some of those funds are reserved as working capital. So if they're held in the business bank account, have not yet been spent, but working capital is not a substitute for funds being spent. So you do need to have already, let's say you're investing $100,000 into the business. It's okay if you have, generally speaking, $20,000 to $30,000 as working capital. You do need to have that, 70 to 80,000 actually spent on the business. Now, the investment amount does depend on the business. So something like a law firm like ours, law firms have very low overhead costs, very low startup costs. So, an investment of 100,000, maybe slightly below, may be okay, particularly if you already have an employee. If you are starting a manufacturing company, then the investment amount is probably going to need to be much, much higher. And so the government, again, does want to see that you've invested enough to get the business operational. So do keep that in mind. It very much is dependent on the type of business. The government has disclosed that it does use something called a proportionality test. And what the proportionality test basically says is the more money that's necessary to get a business started, the lower the percentage of that amount the government will accept as being committed to the business. Now, frankly, I only think about the proportionality test if we are talking about a significant investment amount, and usually we're talking $1 million+. Since we're talking about low investment amount, risky cases, I would generally say to ignore the proportionality test and simply invest 100% of what the business needs to be operational. Because if you are investing $100,000, $200,000 into a business, and that's what's required to get the business started, the government wants to see 100% of that amount invested. If you're buying a business, what is a substantial amount? The fair market value is typically, by definition, a substantial amount if you are buying a business. So this may be relevant if you're buying a business from a family member or a friend. Do be sure that you are paying the fair market value for the business. If it turns out that you're getting a discount on the business, there's a good chance the government will say you did not invest a substantial amount into the business. So I've already touched on some strategies to deal with a low investment amount, but we'll quickly run through these. think about the application holistically. If you don't have a whole lot of money to invest in the business, and your business type doesn't require a significant investment amount, think about the application holistically. Think about what other aspects of the application you can strengthen. So can you employ workers before you apply? That's probably the best thing you can do to address a low investment amount. Other things you can do is to show you already have generated demand for the products or services that the business provides. So execute contracts with customers. If the business isn't operational, sign letters of intent, get letters of intent from people who say, once this business starts operating, I want to do business with it. I'm ready to do business with this company. Include those in the application. You can also get a letter from your local chamber of commerce where the business will be located that says this is a business that we believe is going to have a positive impact on the local economy by creating jobs, by providing services or products that are in demand here. That letter from the Chamber of Commerce can make the difference in a low investment application. A business plan is going to be critical for risky cases. The importance of a business plan is it essentially shows how the business is going to reach the point of employing U.S. workers. And to do that, it's going to walk through all of the projected financials of the company and show what the company is going to sell, how many of those things, how many clients it's going to generate, how many employees it's going to need to provide those products and services. So a business plan needs to be very detailed. We prepare business plans. They tend to be about 30 plus pages, so they are very detailed. Much of that is financial document details, financial projections, as well as employment projections. And you can consider a letter from a CPA, a certified public accountant, which says essentially that they have looked at the financials of this business and that based on their experience, the amount invested is typical for this type of business. So that letter can be important in a low investment amount case. I've already touched on common E2 expenditures. Again, these are expenditures needed for the business to be operational. So I'm not going to go through each of these that you see on the screen, but again, they cover marketing, they cover the operations of the business, office space, things like that. So again, be ready in the interview at the consulate. If the officer says to you, is there anything else this business needs to buy for it to be operational? The answer needs to be no. All I need is the visa. So weak expenditures don't include your travel to the US to meet with clients, to meet with business associates. Travel expenses are considered weak. When you do include them, oftentimes a consular officer will see them and think that you're kind of inflating your investment amount, and you don't want to give that impression. If you are buying a car or a vehicle as part of the business, be sure that the business requires it. So if you're starting a law firm and you have a car as part of your investment, that's going to be a red flag. It's going to be a big problem. However, if you're starting a company that does pool cleaning or an after-school program that's going to bus children around, you need a vehicle. So it's perfectly fine to have a vehicle in those cases. So make sure a vehicle is necessary for the business. Similar to travel expenses, don't include travel accommodations, transportation like taxis, entertainment. If you're entertaining prospective clients or business partners, don't include that. Those are weak expenses. Again, focus on the things that the business needs to be operational and that are really core to that purpose. I'll quickly mention educational expenses like getting a degree or a certificate. If it's you getting that, that is going to be a weak expense as well. However, if it's payments towards, say, a license or a certification that's needed for your specific business, it may well be a fine business expense. With that, I'm going to go ahead and pass it off to Kelly, who's going to speak about unique aspects of consulting businesses.
Thank you, Dustin. So very commonly, we have clients who want to apply for E-2 visas with consulting businesses. And one of the issues they face is that it's hard to find things to spend money on to get yourself to the point where you can prove you've made a substantial investment. So while theoretically a very low investment or almost no investment may be needed for a consulting business, in order to obtain the E-2, you do have to demonstrate that you have invested a substantial amount so that the consular officer or USCIS official adjudicating the case believes that you are committed to successfully operating the enterprise. So even though someone may come and say, well, I have my computer, I have my network, I can, incorporate a business, I really don't need to spend anything else. Uh, you know, what you want to do is consider maybe what you might need down the road in order to run the business and maybe pull some of those expenses that you'll expect to have in years 1 and 2 of the business and spend them earlier so that you can actually, secure the E-2 visa. So the purpose is not to just spend money on things that you don't need, but to spend money strategically in areas where, let's say that you would not have spent a lot of money on a very up-to-date website. Perhaps, but over time it would be very necessary to have that. Perhaps you spend more money on the website up front, or maybe you have a higher marketing spend. Maybe because you're planning to hire employees in years, 2 and 3, you buy the computers and the equipment you'll need for those employees before you file the E-2 case. So you do want to think strategically about how can you spend the money because spending 2,000, 3,000, it's just not going to be enough to convince the officer you've spent a substantial amount, even if hypothetically you could start your business with that small of an amount. Another thing you can do is provide kind of articles, from kind of business publications or magazines that show how much it costs to get your business up and running and point out that you've spent, far more than that amount. Um, and you want to spend on a wide variety of areas. So things like office space. This is a good one because you can actually sometimes prepay for 6 to 12 months. And although, many people argue I don't need an office space. Certainly, remote work is more common than ever. That being said, it does help with the legitimacy of the business to show that you have an actual business address and that you have a place where you'll meet your clients. We do find that even though an office space is not required by the regulations, it is very helpful for the case and it's considered a legitimate expense. So if you're spending money on an office space, this does help your application. Similarly, equipment, so tangible items that will be used for the business. So if you're going to have an administrative assistant, if you're going to have employees and they're going to need work phones or they're going to need laptops or printers or scanners, all of those things are really good E-2 expenses. Marketing is always, a very good expense. Hiring employees. So perhaps you hire an office manager or an administrative assistant to help with some of the setup activities, particularly if you're outside the United States. It can be helpful to have somebody in the US on the ground who is able to, do some of those initial setup activities for you. And anything you pay that employee before you file the case can be included. So you can't include kind of the entire salary that you'll be committed to pay over the year, but if you pay them for 2 months of work before you file, you can include that amount. You can also include any ancillary expenses that are relevant to setting up the employees with the company. So if you get some insurance or you have to pay a payroll provider, all of those are also very good startup expenditures. And you want to spend over a large number of categories, again, to argue you've gotten, everything necessary to start up the business. All right, so let's talk about real estate businesses for the E-2. So real estate can be a challenging area in which to get an E-2. If you are going to file an E-2 with this type of business, you just want to be prepared that you may have an interview where the officer applies more scrutiny to your case. It's, very commonly people will have the, misconception that they can just purchase a property, put it in the name of an LLC and perhaps qualify for the E-2. This is so common. In fact, many consulate, frequently asked questions address this and specifically say you cannot do this. Collecting passive rental income is not going to be sufficient for an E-2. So the challenge here is you want to show that the business is going to be real and operating, that it's actually going to be able to employ workers, generate revenue. We've listed here some kind of potential ideas that clients have used in the past successfully. So things like a real estate brokerage firm, a property management company, renovation or construction, and house flipping. House flipping, this really can only work if you're doing it on a large scale. So if you have just one property that you purchased and you're going to flip, that's really not a good option for the E2. But for example, we had a client who had a portfolio of 30 to 40 homes. So because of the size of the portfolio, there was a lot of activity. There was revenue being generated from homes being sold that was then able to be used to hire construction workers and other people that were needed, for the house flipping enterprise. Another thing you can do is have a business like a real estate renovation or construction business, and perhaps house flipping is something that's a much smaller part of the business. So if house flipping is something that you do want to do, but you're not able to do it on a very large scale, it might be something that you have a different type of business, and then house flipping is another service line that's kind of contemplated down the road. Another thing you have to demonstrate is that you have all the proper licenses to run this type of business. And very often there's kind of state-specific requirements. If you're doing, construction, there might be general contractor requirements. If it's a brokerage, you may need to get some type of real estate license. So you always want to be very sensitive to that to make sure that you have everything that you need in place to actually run the business and make it successful. All right, let's talk about equity trading companies. And these companies have a lot of the same concerns as real estate companies. So one is the concern of, are you just taking your stock portfolio, putting it in an LLC and doing day trading or personal investing, maybe just some investing for friends and family? These are things they're sensitive to. They just want to make sure that there is a real and operating business that's going to have enough revenue to actually support hiring employees in the United States. It's also similar to real estate, a highly regulated industry. So you'll need to show you have the proper licenses. And if there is a kind of more complex structure, for example, if you're setting up a hedge fund or something like that, you need to demonstrate to the officer, how the structure works and make sure you're able to show that the E2 company itself is going to generate revenue and hire employees. All right, let's switch gears a bit and talk about some reasons for E2 visa denials. So one reason would be a low investment amount. And while we've talked about some strategies here to make a case with a low investment amount stronger, it's important to remember that there are some investments that are just too low. To give you an example, we had a client who came to us, had filed their own E2 on their own, and invested $2,000 and put $98,000 in a business bank account. This is just never going to work for an E2. The amount is just too low. So if you do invest or you do apply and you're denied based on a low investment amount and you have a large amount of working capital, it's a relatively easy fix in the sense that you can invest more, resubmit your application, and hopefully get approved. In this particular person's case, we were able to advise them on spending around 50,000, and they went to the consulate and were ultimately approved with spending around 50,000 and having around 50,000 in the business bank account. Another reason for a denial could be the nature of the business. So as we've discussed here, there are some industries that just experience more scrutiny, things like real estate, equity trading, consulting businesses. So again, if you are applying with that type of business, you want to make sure that you're making the case as strong as possible and addressing any concerns they might have up front. Filing location and venue are also very important. Although the law is really the same, consulates tend to have their own ideas about what constitutes a substantial investment. Also, there are some consulates that are used to seeing very large multinational companies that are primarily sending many, many E2 employees. Those consulates may be less friendly to the small business owner who's applying with an investment of $70,000 if they're used to seeing large multinational companies that are spending millions of dollars. Additionally, consular officers rotate over the years and consular chiefs rotate over the years. And so there can be kind of different approaches that consulates will take over time. So it is important to stay up to date on those trends, discuss with your attorney, what the most recent information is. And if you do have an option of where to file, perhaps try to file in the place that, is most favorable given your E2 profile. So the next two reasons for denial are kind of related. Essentially, the concern is, will the business meet the marginality requirement? Will it create jobs for U.S. workers and support more than just the investor and their family? So this is a very big issue for the E2. And if you've run a similar business in your home country for many years and you never hired employees, they may not be convinced by a business plan that you actually plan to hire people. So even if you have a very, strong business plan, but you've run the same business in your home country for 10 years and you never hired anyone, you may want to consider actually hiring someone before you apply for the visa, just to proactively address that concern they would have, that you might not hire people because historically you have not. Other things, issue with an adjudicating officer, so consular officers they're human beings. They have good days and bad days. They also have different levels of training, and different approaches to how they adjudicate E2 cases. If you do feel that you had a very unfair officer, or one who was incorrect in the law, it is something you can discuss with your attorney, although there is very limited ability to, you can't really appeal a consular denial, but you can always refile, and most consulates will try to give you a different officer when you reapply. So it's not a guarantee, but our experience is that consulates will try to accommodate that, so you're not getting the same officer the second time around. Another reason might be that you didn't meet the requirements at the time of filing. So sometimes people will file on their own, or perhaps with attorneys that aren't as familiar with the law. And let's say the treaty country national only owns, 30% of the business and doesn't control it. On its face, that case just cannot be approved. Although if there's an ability to adjust the ownership, then you may be able to reapply, in the future. Let's talk about some adjudication trends. So for approval rates, government posted approval rates for E2s are generally between 80 to 90%, and our approval rate is around 98%. Although, of course, past results do not predict future outcomes. Nobody can ever guarantee that your visa is going to be approved. It's just that's not possible to ever do. I want to talk about some timelines. So, for example, right now in London, they publicly report a review time of 60 working days. Anecdotally, that timeline for review is closer to kind of 90, sometimes 100 business days. So quite a few months, that they're taking to review, and then you can usually schedule your visa appointment within a couple weeks of the time they finish their review. In Toronto, they're taking about, 15 business days, 15 to 20 business days to review the cases. And then if the case is reviewed, they will contact you and allow you to schedule an appointment. And most people are able to get appointments within a couple weeks of being called for their interview. In general, it's important to know that timelines really do vary by consulate. So there are some consulates that are still somewhat backlogged and delayed, that maybe had a slower start getting recovered from the pandemic, where processing times are several months, even maybe a year. There's many consulates where it's much less than that, but the time scale for review does tend to be months as opposed to weeks. So you do want to plan for that when you are thinking about where you're going to apply. One option that you could consider if you really need a fast turnaround and you're in the United States, in a valid status, is filing a change of status with U.S. Citizenship and Immigration Services. So let's say you're in the U.S. on a B1 business visitor visa, or maybe you're on an H-1B and you've been let go from your job, and now you want to start your own business. So filing for a change of status with U.S. Citizenship and Immigration Services is a possibility. The benefit in terms of timing is that you can pay an additional fee to get an answer within 15 business days. This can be an approval, denial, or request for more evidence. If it's a request for more evidence, then generally they will issue a final decision 15 business days after you submit all of your documentation. The downside with a USCIS filing is that you are not going to get a visa stamp that allows you to travel internationally. What you're going to get is an approval notice that allows you to stay in the United States and work at the company, and it's valid for 2 years. But let's say after 1 year you needed to leave, you needed to go home and visit family, or do something abroad. Once you leave the United States, you cannot come back on the basis of that approval notice. You would have to go to a consulate, submit a brand new E-2 application, and get approved for an E-2 visa before you could enter the US. And with some visas, if you get a USCIS approval, you basically take that approval, go to a consulate, and they're not meant to re-adjudicate that approval. They're meant to approve as long as all the other factors, show that you're, a credible applicant and you're not inadmissible. That's not the case for an E-2. Having a USCIS approval does not mean the consulate will approve your case. They will look at the case as a brand new case and make their own determination on whether or not the E-2 should be granted. So if you are someone who needs to travel frequently, a USCIS filing may not be right for you. Another thing with USCIS is that they're very, very strict on the source and trail of funds requirement. So they really want to see exactly where the money originated, show that the money was maintained, and then, where it's gone up till when it's spent on, E-2 expenditures. This is in contrast to a consular filing where they tend to take a much more holistic view. So for example, if you say, I'm investing with money that I saved from my employment over the years. At a consulate, you may be able to provide your tax returns, proof of your bank statement that has the money in it, and then proof of you transferring that, to the US business bank account. With US Citizenship and Immigration Services, they would actually want to see the tax returns, pay stubs showing the money entering your personal account, the money being maintained in your personal account, and if it's transferred anywhere else, they want to see proof of those transfers up until the money actually arrives in the US business bank account. So if the money it has been saved over several years, or there's a lot of different accounts where it was transferred, that can make the case very complicated for a USCIS filing. So let's talk about a consular filing. So as I mentioned, one benefit is they take a more holistic view of the source of funds. Another benefit is that you will get an actual visa stamp in your passport that allows for international travel. And there are many countries where you can be granted a, 2, 3, 4, 5 year visa. And every time you enter, you'll be given 2 years in E-2 status. So you do get both the ability to travel and often a longer period of time in which to run the business, which can help, at the renewal stage because you'll have had more time to make sure the business is successful. Um, Let's talk about some post-specific considerations. So, as discussed on the previous slide, consulates are somewhat different in how they adjudicate E-2s. Although the law is the same, there is some ability for interpretation of what is substantial, what documents they want to see, things like that. So you do always have to look at the consular instructions. Each consulate will have its own very specific way they want things done. Some require files to be mailed in, some, do email. They all have kind of a structure they want. Many have page limits. These are all important things to pay attention to because often they will send the petition back if it does not meet their specific requirements. You also want to be sensitive to the fact that you may need to provide a business plan, and that business plan may need to have a CPA certification. More and more, consulates are asking for this, where they actually want a CPA to have looked at the financial statements in the startup business plan and certify that these are, reasonable and accurate. Okay, let's turn to some issues and complex areas for E2s to keep in mind. So, very common question, do I have to hire employees before I apply for an E2 visa? And the answer is no, it is not a requirement that you hire employees before you file. That being said, there are some consulates that strongly prefer this. Taiwan comes to mind, where they are much more focused on, looking at employees and seeing if employees have been hired. That being said, it's not a requirement, but it does strengthen your case. And if you're in that situation where you were running a very similar business and you didn't hire employees, it's a very good idea to hire employees before you file if possible. Another area is a complicated source and trail of funds. So as I described in the previous slide, for USCIS, a very complex source and trail of funds can be quite difficult. If you are not able to produce the full trail of funds and where all the money was, if it was transferred to multiple bank accounts, they may not be willing to move forward with the case. They may deny the case on that basis. So it is a very important part of the application. Loans are permitted for the E2 investment as long as they are secured by the investor's personal assets or unsecured. What does not work is if they are secured by the assets of the E2 business. So, for example, if you purchase a business and a portion of it is seller financing, or a portion of it is a loan from a bank that is secured by the actual business assets. This is not going to work for an E2. They want to see that the investor's personal assets are at risk and fully committed to the business. So, for example, if you own a home and you took out a home equity line of credit, that would be fine as funding for an E2. Gifts can also work for the E2, but these gifts, you would need to make sure that the gift giver is willing to provide you with proof of where they got the money. So having a gift does not eliminate that requirement that you show the money comes from a legitimate source. So you would need to make sure that, let's say it's your parents giving you a gift and they sold the property. They're willing to provide you with the purchase sale agreement for the property and the proof of them receiving the money or paying taxes on the money before they transfer it to you. People will often ask whether E2s are available for two investors, and this can work as long as the ownership is 50-50. If the investors have the same nationality and they, for some reason, cannot have a 50-50 ownership split, you could also consider an investor and an employee application. But again, the nationality would need to be the same. So substantive changes to the E2 business after filing. Sometimes people have the impression that once they secure their visa, any changes to the business don't matter because they have a valid visa. And this is not the case. So when you get your visa, you are being authorized to run the business that you represented to the consulate. So any changes in ownership that would take the treaty country nationality below 50%, are problematic for maintaining E2 status. And similarly, any major changes in the type of business could be problematic. So if you originally were approved for an E2 to run a restaurant and you shut down the restaurant and start a wedding photography business, that is not going to work. You need to first go back and get an approval for that new type of business before you go ahead with it. That being said, if you're running a restaurant and you decide you're going to add baked goods and provide a bakery as part of this, enterprise, that's likely fine because that could be described as a natural outgrowth of the type of business you're already doing. So if you do have different business ideas, one thing you can do is try to include them in your initial business plan so that then later down the road, you're able to do them without having to go back to the consulate or USCIS and get an approval. Another thing you can do is if you decide, hey, I want to change the direction of my business, I'm worried about this, is you can ask USCIS for an opinion as to whether this is considered a substantial change. So these are kind of important things to keep in mind because what you don't want to do is make that change, not contact the consulate or USCIS, and then when you go to renew, now you have issues because you could potentially be viewed as having violated your status because you've totally changed the business without getting a prior approval. So family business purchases, these are possible to use for an E2, but you do want to be careful. Make sure that you have documented the sale, that it's legitimate, that the amount that you've paid makes sense in light of the financials of the company. Often a good idea to have a lawyer, draft the purchase sale agreement and also to get perhaps a valuation, from a valuation company or CPA that explains that the amount you paid is the fair market value for the business. So, lots of questions about the impact of the current administration. When this administration previously in 2021, they had issued an executive order called Buy American, Hire American. And although that executive order is not currently in place, the ideas behind it are still relevant in the sense that there is an enhanced focus on making sure that the business is beneficial to the United States. We, recommend that you spend most of the investment in the United States, although this isn't a requirement. For example, if you get inventory from abroad, that's fine. That's a legitimate E2 expense. But anywhere that you're able to spend the money in the United States, like purchasing equipment, computers, software, other vendors, it is beneficial to use US vendors. And it's also beneficial to show that you'll be hiring a lot of US workers as opposed to hiring, E2, a lot of E2 employees or, third country nationals. So approval rates did not change much from 2016 to 2020. And we, do not anticipate that they'll change much, during this administration either. But it is important to keep in mind that adjudications will likely be, more strict, and there'll be enhanced vetting of applicants as well. Right.
All right, perfect. Thank you so much, Kelly. And we have a handful of questions. We have 5 minutes left in the presentation, so do send in any other questions that you all have. So Kelly, you answered this first question. I was told that you could start a property maintenance company to look after your own rentals or others. Anything you want to add to what you already shared in response to that question?
Yeah, so I think this can work. If you're, again, it's better to have other rentals that you're managing as well, on top of your own rentals. If you're only using rentals that you have, you would want to have a large number of them, a very large portfolio to show that you would have enough work, to support workers in the United States.
Perfect. And then this next question, can you take out funds from a secured or an unsecured line of credit to fund the business?
You can, yes, that's fine. Again, though, as long as it is not secured by any assets of the E-2 company. So if it's your personal line of credit that's secured or unsecured by your personal assets that aren't the business, that's fine.
Perfect. This next question is really what it's getting at is starting a business while you're in another visa status. So I gave the example before of someone who is an F1 student studying accounting. Um, if they were to start their LLC while they're a student, not actually get it operational, but start the business, in terms of establishing it, investing in it, getting it to the point of being operational, but not actually starting to sell services. Generally speaking, that is fine to do. Where I think we would definitely encourage a lot of caution is if you start to take steps to actually provide services to customers, because you really want to make sure that you don't violate any prohibitions on working in the US. That would need to be disclosed that can affect your ability to get visas in the future. But the answer is that in general, even coming into the US on a B1 visa, a business visitor visa, it is fine to set up a company and to take steps to get it to the point of being operational. Um, if you want the business to become operational before you apply and you don't have status in the US to do that, it is fine to hire someone in the US who can manage the business and start selling and generating income. As long as you are not in the US doing that, that will not create work authorization issues. So if you want the business to be operational and you don't have work authorization, do be sure to have someone in the US who is able to do that. Kelly, anything else you wanted to add to that one?
No, I think that's exactly right.
Okay, so this next question is really close to the first one. My business focuses on reselling. I'm planning to invest 100,000 and spend around 15,000 on inventory. Is this amount enough? I'm going to just quickly say it's really impossible on the face of it to say whether an investment amount is enough or not. This is not a binary question like, say, the EB5, where you meet a dollar amount and you're okay. So what we do with our clients, we look at the business holistically to help figure out if it would be considered risky or not. But spending $15,000 on inventory can be fine if you're spending on other things as well, like equipment and office space, employee payments, things like that. So you really do need to look at that investment holistically. And again, if you're focused on reselling, just make sure the business will employ U.S. workers. So, if you're going to need U.S. employees to perform the services, that's essential to an E-2. Do you work for nationals of Bangladesh? We do. We are fortunately able to take clients from anywhere in the world because we practice immigration law. It is not state specific within the US. So, really, anywhere in the world, Bangladesh is an E-2 treaty country. So, yes, we would be happy to help. I currently applied for my STEM OPT. Kelly, I'm going to probably ask you for your input on this one. I currently applied for my STEM OPT extension and want to continue working on my startup idea of a web platform. Can I transition from my OPT period to an E-2 visa later in the future and seek immigration benefits?
Yeah, so you can do that. It is possible to transition from an F1 and be on OPT and get an E-2 visa. One thing to be cautious about is that when you're on OPT, self-employment is very clearly permitted. So if you started up your own company and it's, related to the type of degree that you had, you could kind of, work at that company and then kind of transition to an E2. When you're on STEM OPT, it's more complicated because self-employment and ownership are not permitted in the same way because there has to be a training plan and a level of supervision. So from STEM OPT, it might be a little bit more complicated in terms of whether or not you're permitted to actually keep working on your own company while you're on STEM OPT. So if you're saying, I have a STEM OPT employer and in my free time, I want to work on my company, I'd say you want to, any setup activities you do that are pre-revenue, would be okay. But you want to be very careful about actually starting to work at that company until you would have, specific work authorization under the E2.
Perfect. And I think they just added that they have an American co-founder as a manager. So that's especially a good step just to make sure you're not crossing that line into unauthorized work. Well, great questions, Kelly. Thank you so much for sharing your expertise. To you all in the audience, thank you for your participation. Please do keep an eye out for the email that we will send. Schedule a consultation if you have any questions at all. I'll quickly just say we did get a question. Are my chances lowered if I use escrow? No, you can use escrow. Escrow is really the only exception to actually spending money on the business. I said before you need to commit funds to the business. The only exception to that is if you put the funds into escrow and the sole condition is issuance of the visa. So great question. If any of you have additional questions, do schedule a consultation with us. Visit our YouTube channel. We do hope to see you on future webinars as well. And in the meantime, stay well.
Thank you.